New York is arguably the most tenant-protective state in the entire country when it comes to habitability. And it's not even close. If you're a landlord here, especially in New York City, you're operating under one of the most complex and heavily enforced regulatory systems in the nation. At the state level, New York's implied warranty of habitability is codified in Real Property Law Section 235B. This statute makes it clear that in every residential lease in New York, there is an implied warranty that the property will be fit for human habitation and that the tenant will not be subjected to conditions that are dangerous, hazardous, or detrimental to their life, health, or safety. And this warranty cannot be waived. Any lease clause that tries to eliminate it is void. Under New York law, landlords must maintain the structural integrity of the building, provide adequate heating, and in New York, heat season runs from October 1st through May 31st, with specific minimum temperature requirements depending on the time of day. You must provide hot and cold running water, with hot water available year-round. Maintain plumbing and electrical systems. Keep the property free from pest infestations. Maintain working smoke and carbon monoxide detectors. Ensure adequate fire exits and safety measures. And keep common areas clean, lit, and safe. Now, if your property is in New York City, the requirements multiply. The New York City Housing Maintenance Code, administered by the Department of Housing Preservation and Development, or HPD, is one of the most detailed housing codes in the world. It covers everything from minimum room dimensions to window guards in apartments where children under 11 reside. Lead paint requirements for buildings built before 1960, required levels of hot water temperature, elevator maintenance, and even the minimum number of electrical outlets per room. HPD actively enforces the housing code through its inspection and violation system. Tenants can call 311 to file a complaint, and HPD will send an inspector. Violations are classified as A, B, or C, with C violations being immediately hazardous and requiring correction within 24 hours. Landlords who fail to correct violations face fines, and HPD can initiate emergency repairs at the landlord's expense. New York tenants have powerful remedies. They can withhold rent, and New York is one of the states where rent withholding is a well-established right, though it comes with risks if a court disagrees on severity. Tenants can pursue HP actions in housing court, which are special proceedings designed specifically for habitability complaints. They can seek rent abatement, meaning the court can retroactively reduce the rent for the period during which conditions were deficient. And they can file for harassment claims if a landlord deliberately allows conditions to deteriorate. New York's anti-retaliation protections are equally strong. Under Real Property Law Section 223B, landlords cannot retaliate against tenants for making good faith complaints about habitability to government agencies, and the protection extends for a full year after the complaint. For the complete guide to New York habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state and jurisdiction in our series.